Hi, everyone. Let me just log in to all my platforms. I'm just going to wait for some of you guys to tune in. Good morning. Happy Thursday. Say hi in the comments. If this is your first time joining me on Instagram, Facebook, YouTube, definitely shout out in the comments. Let me know where you're tuned in from so I can give you a shout out. And thanks for joining me. Um, and if you're not new and this is not your first time, still definitely say good morning. Let me know where you're tuned in from. Good morning, Tanya on Instagram. Good morning, Chris on Instagram. Um, so I'm just going to wait for some people to trickle in. So while people are trickling in, some household items. For those of you on Instagram, you can find my phone number in my profile. It is 407-995-6567. If you want to send us a WhatsApp message, you can send us a WhatsApp message. The WhatsApp is 404-333-8751. And then if you're on Facebook or YouTube, you can see the phone number scrolling through the ticker. So definitely save that. Good morning, Favor Carey from New York. So let me introduce myself. For those of you tuning in for the first time, my name is Aisha Chidole. I'm an immigration attorney. I represent clients in all 50 states, so your location doesn't matter with humanitarian-based immigration, family-based immigration cases. So definitely give me a call if you need assistance, or if your friends or your family or your cousins, aunties need assistance, share this video, one of the ways that you can show appreciation for me coming here, sharing these information with you guys is sharing the video. Let other people know what's going on and what they qualify for. Ashfra, good morning from Bangladesh. Thank you so much for tuning in. Justina says, good morning, Aisha from LA. Keep up the good work. Thank you for all the information you give out for free. Share this video, please. Thank you so much. Yes, guys, please share this video. And I'm happy to do it. Okay, so if you guys are just tuning in for the first time, you would know that you can definitely ask me some questions. If I am able to get to your questions, I will answer them. If I cannot, you can always schedule a consult, but I'm just going to talk about my topic, but feel free to, type your questions and then I'll get into all of them. So today I just want to talk about those that are married to green card holders and what their options are. So, a lot of times, you guys hear me talking about, when you're married to a U.S. citizen, your U.S. citizen can petition for you if you meet certain requirements, whether it's here in the United States and whether it's outside of the United States. So, for instance, as a U.S. citizen, as somebody who's married to a U.S. citizen, if you came into this country with any form of visa, your U.S. citizen, guys, just give me a second. Let me put on my lighting that just fell off. Okay. So if you're married to a U.S. citizen, your U.S. citizen can petition for you while you're in the United States, as long as you came into the country with a visa. But there's specific visas that will disqualify you. Like, so for instance, like if you came in on a crewman visa, they won't be able to petition for you that way. Or if let's say you're in a J1 and you have a 2-year requirement and you've not gotten a no objection waiver, they won't be able to file for you, right? But generally, they can file for you while you're here, even as an overstay. The requirements are very different when you're dealing with a green card holder. So that's something that I just want to break down. And I'm going to break it down into 2 different categories. Green card, people who are married to abusive green card holders, and people who are married to loving green card holders, and everything is going wonderful. So if you're married to a green card holder and everything is wonderful, life is great, in order for you to adjust your status within the United States, one of 2 things have to happen. One, you have to have entered into this country legally by one of the visas I mentioned earlier. Number 2, you have to be in status. You have to be in status. So that is one of the critical differences between a green card holder and a U.S. citizen, meaning that in order for your green card holder to petition for you, One, you have to be in status, meaning that you've not overstayed the time that Customs and Border said you should stay here. So traditionally, they would say they will give you 6 months entry. So you have to be within that 6 months, number one. And then number two, a visa has to be available. They call it a visa, but essentially what it means is that a green card has to be available. Like, it's called an immigrant visa when you're in a preference category. So those two things have to be available in order for you to do it that way. Okay. I'll give you the other option for you if you're in a loving and married relationship, but I just wanted to quickly talk about this. And right now it is available, meaning visas are current. I don't know what has been happening, but the last 2 years, because I'll say this started in 2020, and maybe it's the COVID that we have to thank for it, visas have been current for spouses of green card holders and children of green card holders under 21. So you already have one check mark saying that that is current. So the other check mark is that you must be in status to now do it that way. Now, if you're not in that situation, or you're not in status, and visas are current or whatever it is, and you just have overstayed your my Instagram keeps disappearing on me, guys. Can you guys see me on Instagram? Okay. So if that is not the situation with you and you're out of status, the other alternative way that you'd be able to adjust your status and get your green card is if your green card holder spouse converts to a US citizen. And in order for them to convert to a US citizen, they have to be qualified to convert to a US citizen, meaning that they've had their green card for 5 years, they've put in the application for naturalization, they pass the naturalization, they do their oath ceremony. If that happens, then you can do an adjustment of status. You also have the option of either selecting to do your the first initial petition for alien relative, and then waiting for your spouse to naturalize if your spouse is already due to naturalize. Personally, I wouldn't do it if your spouse has some time off before they naturalize. So those are the ways in which you can adjust your status while you're in the United States if you're married to a green card holder. If you don't meet any of these requirements, your option is that you would have to leave the country to finish the process. And before you leave the country, you have to get what we call a hardship waiver, which has to be approved, saying that there'll be hardship to your your green card holder spouse, or your green card holder or U.S. citizen parent. I'm sorry, your U.S. citizen parent and your green card holder spouse or whatever. So the second category that I wanted to talk about, green card holders, are people who are in abusive marriages. So you guys know with law, there's always an exception to the rule of everything. This, if you are in an abusive marriage and you're otherwise eligible to submit a VAWA self petition, you can do that while you are in the United States, even if you're an overstay. So that is one time they will make an exception. So if a green card, if green cards are current, which they I'm sorry, I said green cards. If visas are current for green card holders, spouses, and children under 21, and that spouse is abusive, you can file simultaneously for an adjustment of status, just like as though your spouse was a U.S. citizen, and get your work permit, get your 2-year green card without ever leaving the country. So if you're in a situation where your spouse is abusive to you, whether it's emotionally, whether it's psychologically, whether it's verbally, whether it's financially, whether it's sexually, or physically, and they're green card holders, you're eligible to adjust your status within the United States because, as I said, visas are current and they've been current for the last 2 years. So this is a knock on wood. We don't know how much longer that this is going to stay current, but as of the month of October, they are current. So if you fall in that category, you want to do it now. And just to put that in context for you guys to understand the urgency of it, is that every month they change, visa availability and when it's available for what we call family preferences, which is what green card holders are considered. And, sometimes it could be a 2-year wait before you can even submit that. So even if you submit your vow petition, you cannot submit an adjustment of status for at least 2 years. So you have to wait at least 2 years to even put in an application for a work permit or an application for a green card. But thankfully, right now, they're current. So if you fall in that category, you can definitely submit your petition now. Okay, so let me take some questions. Thomas says, morning to the best lawyer near anyone. God bless you for the good job. Thank you so much. Good morning, Tina from Austin. Okay, so Facebook, you guys are very quiet today. Let me go to Instagram and see if I have questions. Hello, Timmy Tukwe. Hello, Benjamin. Good morning, Tanya. Okay, married to a green card holder but not registered with the state of Illinois. Should I put single or married on my naturalization? I'm not going to tell you what to put on your form. If you're married, you should know what you should be putting on your form. You're not single. I don't understand what married and not registered means. Okay, let's see. What other questions do I have? Good morning, Judine Pink. Somebody says on Instagram, Inquest says, what happens when you marry a U.S. citizen and you're in removal proceeding? Will you still be temporarily removed for re-entry? So the answer is it really depends. It's up to the judge to decide. Also, just note that if you are in removal before you marry, the standards of proof become higher. And what I mean by that is that, if you were married and then you entered removal proceeding, the standards of proof is the lowest standard of proof, meaning as long as it's 50% plausible, and I'm just using that to make it easier in layman's terms, as long as it's 50% plausible that, this is a legitimate marriage, that is what they're going to be using. And then if you enter into removal proceeding and then you go marry a U.S. citizen, now the standards are up by 75%. Now you have to prove with 75% certainty that you entered into this marriage and it wasn't because you were in removal proceedings. And if the judge determines that, you have a legitimate bona fide marriage, they will usually either terminate or withhold removal, but that will be up to the judge to decide what to do for you. Okay. All right. Do you guys have any other questions today? Okay, let's see. Let me make sure I didn't miss any questions. Okay, guys. Well, today was a quiet day. So please definitely share my video. If you want to schedule a consult, call me 407-995-6567. You can also send a message on WhatsApp, 404-333-8751, and I'll be happy to speak about your particular issue with you. All right, guys, I hope you have a lovely day, and I will see you here tomorrow, Friday. Bye.